Hi everyone, I am Sharada Mani, Assistant Professor, Department of Commerce. Today we discussed about the case study in the title of the Incorporation. Okay, let's see. Before that, what is meant by incorporation? It is the legal process of forming a corporation of or company, creating a designation legal entity separate from its owners, which protects personal assets and offers liability protection, often requiring registration with government bodies like a register of the companies, and involving steps like name reservation, filling key documents, that is a memorandum of association and the article of association, and obtained a certificate of the incorporation. Beyond the business, it can also refer the act of including something into a larger whole, such as integrating new ideas or a new city into a governmental structure. In that, we take a case study about the mandatory CCI approval in IBC resolution plans, that is Independent Sugar Corporation Limited versus Girish Girish. It occurs in 2025. The background of the case study is Hindustan National Glass and Industry Limited, a major player in the glass packing industry, entered into the Corporate Insolvency Resolution Process under the IBSC. The Committee of Creditors received the resolution plans, including one from AGI's Greenpac Ltd. The expression of interest and request for resolution plans explicitly required prior approval for the Competition Commission of India for any plan that could trigger a combination under the Competition Act 2022. AGI Greenpac plan involving significant market consolidation. However, resolution professional allowed the plan to process COC voting with the prior CCI approval. The COC approved it with required majority. Let's see what the solution is.
To talk about the case study in incorporation. Voluntary CCI approval in IBS resolution. Independent Sugar Corporation Limited, Chris Sharma, Juneja and ORS 2025. Background facts. Hindustan National Gas and Industrial Limited HNGIL, a major player in the glass packaging industry under the Corporate Insolvency Resolution Process CIRP under the IBC. The Committee of Creditors COC received the resolution plan, including one from AGI Greenpac Ltd, the large competitor in the glass, considered select statement. The explanation of interest EOI and the request for resolution RFRP explicitly required a fair approval from the Competition Commission of India CCI for any plan that could trigger a competition under the Correction Act 2002. Potential market domains are required competition post acquisition.
Independent Sugar Corporation Ltd. Another unsuccessful resolution of different challenges before NCLT. Arguing that the provisional section 81 of the IBC made clear CCI approval mandatory before COC approval of such plans. The NCLT and later the NCLT treated the requirement as non-mandatory, held the plan and dismissed the challenge of dismissed IBC priorities, timely resolution over procedural.
Key legal issues is the provision of section 81 of the IBC, which stated that the legislative plan in value of competition under section 5 of the Competition Initiative, where ICCI approval is required mandatory or fairly include also to the relationship of the application, sale, obtain the approval of the competition of the Indian under that AGI provide to the approval of six relationship plan of by the Committee of Creditors. Can the COC approval a relationship plan that may credit anti-competitive implication without provide ICC no those risks undermine the object of both IBC. The what is the constitute of non-completion and rejection of the plan or can post approval of CCI cleared service.
Supreme Court ruling. A benchmark and majority view by Justice Roy and Juneja the provide to section 31 for IBC is monetary, not directory. Prior CCI approval must be obtained before the COC board and approves the resolution plan in cases involving a combination. The board set aside the NCLT and NCLAT orders approving the AGI plan resolution. IBC and Competition Act the status one connect overall with the others, allowing COC approved without CCI clearance risk approving anti-competitive competition. Effect the purpose of competition law. Timely resolution under IBC connect come at the cost of statutory. Under another law, the monetary nature protects public interest, prevent market and ensure hostility compliance. The Supreme Court that will IBC armed from speed. It is not absolved.
Outcomes and implications. The resolution was invalidated for non-compliance. The matter was remanded for fresh consideration in line with the mandatory requirement. This ruling has far-reaching impact on M&A style resolution plans in connected industries. For example, cement, telecom, metals, packaging, and e-commerce. Resolution applicants must now secure prior CCA approval, which can take months depending on the respective government, before COC voting. It increases timeline risk but strengthens the competition safeguards. Promoters or resolution professionals must build CCI timelines into the process early on. Relevant provisions. So, what are the relevant provisions from the above mentioned case? Section 31 of 4 IBC provides mandatory prior CCI approval for combinations. Section 5 and 6 Competition Act 2002 defines combinations and notification thresholds. Section 31 of IBC. Overall, adjusting the authority approves related compliant plans. Related landmark references. So, what are the landmark references mentioned? The bills on early IBC jurisdictions like Committee of Creditors of HNGIL V. Satish Kumar Gupta. It is a commercial of COC Paramount, but within the statutory bounds, it is the V. Satish Kumar Gupta is a commercial, which is the owner or the founder of it, aligns with the Supreme Court's push for inter-statutory harmony. Example, in environmental clearance cases. This case illustrates how law in India increasingly balances revival of distressed companies with broader public interest goals like fair competition. It is particularly relevant for manufacturing, infrastructure, and sector-specific consideration. Since you are in Coimbatore, a major textile hub, note that similar CCI scrutiny could state arise in further textile or garment sector insolvencies involving large consolidations. Thank you.